You are on the phone with someone you love, and something goes wrong. Maybe the call cuts off mid-sentence. Maybe you hear something you cannot explain. Maybe they say something that terrifies you and then go silent. Your next move, calling 911 and asking for a welfare check, feels obvious in the moment, the only thing you can actually do from wherever you are standing. But what happens after that call, whether police can actually go inside to check on them without a warrant, used to depend on which state you were standing in and which judge eventually reviewed the case months or years later, long after the moment that actually mattered had already passed. On January 14th, 2026, the Supreme Court settled that question for the entire country, unanimously, in a case that started with exactly the kind of phone call I just described. If you have ever wondered what actually happens, legally, after you make that call, or you are worried you might have to make one someday, this is the ruling that answers it. Quick thing before we get into it. I cover Supreme Court rulings that intersect with real, difficult moments people actually go through, not just abstract legal theory disconnected from anyone's actual life. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into what the court actually decided, and what it means for you specifically if you are ever the one making that call, or the one someone else is making that call about. The case is called Case versus Montana, and the facts behind it are the kind of facts that make a legal ruling feel a lot less abstract than most Supreme Court cases usually do. William Trevor Case called his ex-girlfriend and told her he was going to write a note and kill himself. During the call, she heard a sound consistent with a gun being cocked, then what sounded like a shot, then the line went silent. She did what most people in that situation would do. She called 911. Montana police officers arrived at his home within minutes, knocked on the door, and shouted his name into an open window. No response. Looking through that window, officers could see an empty handgun holster and what appeared to be a suicide note sitting nearby. They tried to make contact again. Still nothing. At that point, the officers made the decision to enter the home without a warrant, specifically to check whether Case was alive and needed emergency help. This is exactly the moment where the law becomes genuinely important to understand, because what happened next in Case's specific situation, an officer encountering him hiding in a closet and a shot being fired, is not really what this ruling is about. The ruling is about the decision that came before that, whether the officers were legally allowed to open that door in the first place, based only on what the caller had told them and what they could see and hear for themselves. Case survived, and in the criminal case against him afterward, his defense argued that the officers had violated his Fourth Amendment rights by entering without a warrant, meaning everything discovered inside should be thrown out of court. A legal argument that, if successful, would likely have unraveled the entire prosecution against him, regardless of what happened once officers were inside. A trial court disagreed, a jury convicted him, and the case worked its way up through Montana's own court system, where a divided state Supreme Court upheld the conviction using a different, less precise legal standard than the one the U.S. Supreme Court would eventually settle on before the case finally reached Washington, which took it specifically to answer one clear, narrow question. When someone calls for help on behalf of another person, exactly what does an officer need to legally justify walking through that door? Before this ruling, the honest answer to that question depended heavily on where you lived. Some courts around the country had drifted toward requiring something close to probable cause, the same high legal bar used to investigate an actual crime, before officers could enter a home to check on someone's safety. Other courts had drifted the opposite direction, applying something closer to a low-level hunch standard. If you were the one making that 911 call, the actual legal protection your loved one had, and the actual legal risk the responding officers were taking on by walking through that door, genuinely varied by jurisdiction in a way that most people calling in a moment of panic would have no way of knowing, and no reasonable person should be expected to know. In the middle of the worst moment of their life, which specific legal standard happens to govern the county they are standing in? Here is what the Supreme Court actually decided, unanimously, all 9 justices agreeing. A level of agreement that is genuinely rare in Fourth Amendment cases, given how often they divide the court along more predictable lines. Officers can enter a home without a warrant to check on someone's safety if they have what the court called an objectively reasonable basis for believing that person is seriously injured or in imminent danger. That is not probable cause, the standard used to investigate crimes, and the court was explicit and direct about rejecting that higher bar for this specific kind of situation. Justice Elena Kagan, writing for the full court, explained the reasoning in terms that matter for anyone who has ever been in the position of making that call. Checking on someone's safety is not a criminal investigation. It is not about gathering evidence or building a case. It is a fundamentally different kind of question, whether someone needs help right now, and forcing that question through the same legal framework used to investigate crimes does not fit the situation, since probable cause is built around the likelihood that evidence of a crime exists somewhere, an entirely different inquiry than whether a specific person is safe at this exact moment. Now, here is the part that actually matters most if you are the one calling, rather than the one being checked on. The court looked specifically at what information the caller in this case had provided, and what the officers could independently see and hear once they arrived, and it walked through why that combination met the standard. A direct statement of intent to harm himself. The sound of what seemed to be a gun being readied and fired, heard live during the actual call. The call going completely silent immediately afterward. Visual confirmation through the window of an empty holster, and what looked like a note. And no response at all after repeated attempts to make contact. None of these facts on their own might have been enough. Together, stacked up, they were. This is worth understanding as a method, not just a list, because the court's approach here is to weigh the full, combined picture rather than testing each individual fact in isolation against some fixed checklist. A defense attorney trying to argue an entry was unlawful will often try to pick apart each fact one at a time. The holster alone proves nothing. The note alone could have meant something else. The silence alone might just mean he did not want to talk. The court's method explicitly rejects that kind of piece-by-piece dismantling in favor of asking whether everything together, viewed the way a reasonable person actually standing at that door would have viewed it in the moment, adds up to a genuine, reasonable belief that someone needs help. This matters enormously for understanding what to actually do if you are ever in this position yourself. The more specific, concrete detail you can give a 911 dispatcher, exactly what you heard, exactly what was said, exactly when the call went silent, whether you can see anything relevant through a window or from outside, the stronger the legal basis officers will have to act quickly rather than treating your call as one more unclear, ambiguous report among many they receive every day. And the more of these specific details you can stack together, the more clearly your call resembles the exact pattern the Supreme Court itself found sufficient in this case. I want to be honest about something the court itself had to wrestle with directly, because it is a real fear worth naming rather than glossing over. Case's defense argued that the officer's decision to enter is what actually created the dangerous confrontation that followed, sometimes described as a suicide by cop dynamic, and that this risk should have made the entry itself improper. The court did not dismiss this concern as unimportant. It acknowledged directly that the possibility of an intervention escalating a crisis is a real, legitimate factor, one that genuinely belongs in the analysis, not something to be waved away or pretended does not exist in situations involving a firearm and a person in crisis. But it concluded that officers facing a call like this one are choosing between two real risks, not a clean decision with an obviously safe option. Doing nothing carries its own serious risk, that someone who may have already hurt themselves is left without any help at all, potentially for a fatal amount of time, while officers wait outside for a warrant that could take hours to obtain, even under the best circumstances. Acting carries a different risk, that the situation could escalate in an unpredictable way. Exactly what happened in this specific case. The court's own words on this point are worth sitting with directly. The Constitution did not require the officers to leave him to his fate. That sentence is not really about legal doctrine. It is a statement about what the law asks of someone responding to exactly the kind of call you might make on the worst day of your life, and it reflects a considered judgment that the risk of inaction in a situation this specific and this serious outweighs the risk of a well-intentioned intervention going wrong, even though the court was careful not to treat that balance as automatic or guaranteed in every single case with different facts. If you are ever in a position where you need to make this call yourself, here is what this ruling actually means for you practically. You do not need to have every fact perfectly organized or use any particular legal language when you call. What you should try to do, as much as the situation allows, is give the dispatcher the specific, concrete details you actually have, not just a general sense that something feels wrong. Officers responding to your call are legally allowed to act on exactly that kind of specific information, and this ruling confirms that they do not need a warrant or anything resembling proof of a crime to go check. They need a reasonable, fact-based belief that someone needs help right now. If your call is vague, if you genuinely have very little specific information beyond a general worry, understand that the standard still requires something concrete. So any detail you can offer, no matter how small it feels in the moment, genuinely helps the people responding. Do their job faster and with more legal confidence to act decisively rather than hesitating at the threshold. Let me clear up two things people commonly misunderstand about this ruling, because getting them wrong could genuinely affect how you handle a real situation. The first misunderstanding is thinking this ruling means police will now enter any home whenever anyone calls with any level of concern. That is not what the standard says. It requires specific, articulable facts, not a general feeling, which means a call with essentially no concrete detail behind it, just a sense that you have not heard from someone in a while with nothing more specific attached, may not on its own meet the bar this ruling actually sets, even though officers may still choose to check in through less intrusive means first, like knocking and waiting, before considering whether entry is legally justified. The second misunderstanding is thinking this ruling only matters if things go wrong the way they did in the underlying case, with a confrontation or an injury. It does not. The vast, overwhelming majority of welfare checks conducted under this exact standard resolve without any confrontation at all. Officers arrive, make contact, confirm the person is safe or get them help, and leave. And this ruling protects that far more common, far less dramatic outcome, just as much as it addresses the rare case that ends up back before a court. It is also worth knowing what to do if you feel like your concern is not being taken seriously enough on the phone, because this happens more often than people expect, and it is not necessarily anyone acting in bad faith. Dispatchers are working from limited information and have to make fast decisions about how urgently to treat every call they receive, often while juggling several incoming calls at once during a busy shift. If you feel like important details are being lost or rushed past, it is reasonable to slow down and restate the most specific, concrete facts you have, exactly what you heard, exactly what was said, exactly how much time has passed since you last had contact, because those specific facts are precisely what this ruling says actually matters for the legal standard officers will be operating under once they arrive. A general statement like "I have a bad feeling" carries far less legal and practical weight than a specific one, like "he told me he was going to hurt himself and then the phone went dead," even though both might reflect the exact same underlying fear. If you are on the other side of this, someone officers might be checking on, understand what this ruling does and does not allow. It does not give officers a blanket right to enter any home based on a vague, generic worry with nothing behind it. It requires specific, articulable facts pointing to a real, serious risk to someone's safety, evaluated based on what the officers actually knew and observed in the moment, not a hunch or a general sense that something might be wrong. And it is worth knowing, if you are ever the person police are trying to reach during a crisis, that responding to them, showing yourself, communicating that you are safe, is very often the fastest way to end the encounter, since the legal basis for entry depends entirely on officers having a genuine, ongoing reason to believe you are in danger, a reason that dissolves the moment you are able to confirm directly that you are not. This ruling sits within a longer 20-year history that is worth knowing, because it shows this is not a new or experimental legal idea. It is the court reaffirming and clarifying a standard it first set in 2006. That original case, Brigham City versus Stewart, involved officers responding to a noise complaint who saw a violent physical altercation through a window and entered to stop it. A follow-up case in 2009, Michigan versus Fisher, applied the same standard to officers who found a damaged vehicle, visible blood, and an agitated, injured man through a window. Both cases established that officers need an objectively reasonable basis to believe someone is seriously injured or in imminent danger, not proof of a crime. What had happened in the years since is that different courts around the country had drifted away from that original standard in inconsistent directions, some requiring more, some requiring less, and Case versus Montana exists specifically to pull that drift back to the original single national standard, reaffirming it in language precise enough that lower courts do not have much room left to quietly deviate from it again in either direction. Notably, the Montana Supreme Court itself, in upholding Case's conviction before this case reached Washington, had applied its own state-specific community caretaker doctrine, language that actually tracked a lower standard than what the U.S. Supreme Court ultimately confirmed applies, meaning even the court that got the underlying outcome right had reasoned its way there using the wrong legal yardstick, a detail two justices flagged directly in their own separate writings even while joining the unanimous result. I also want to mention something practical and separate from the legal ruling itself, because if this topic resonates with you personally, the legal question is only part of the picture. If you are worried about someone you love, or you are the one struggling right now, the 988 Suicide and Crisis Lifeline exists specifically for exactly this kind of moment, reachable by call or text, and it is staffed by people trained to help in a crisis without it needing to become a law enforcement matter at all in many situations. Many areas also have mobile crisis teams or co-responder programs, specially trained clinicians who can respond alongside or instead of police depending on the specific situation and what your local resources look like, an option worth knowing about before you need it, rather than discovering it for the first time in the middle of an emergency. Knowing that resource exists before you are in the middle of an emergency is worth having in your back pocket alongside understanding what officers are legally allowed to do if a 911 call does become necessary, and the two are not mutually exclusive. Sometimes the right response involves both, a crisis line for immediate support and 911. If there is an immediate, serious safety concern that genuinely needs an in-person response right away, step back and look at what this ruling actually accomplishes for someone in your position. It removes the uncertainty about whether officers responding to your call for help are operating under a legal standard that varies depending on which state or circuit you happen to live in. Uncertainty that, before this ruling, meant the exact same phone call could have produced meaningfully different legal outcomes, depending purely on geography. It confirms that a specific, detailed account of a real emergency, even one delivered in a panic, in the middle of the worst moment of someone's life, is exactly the kind of information the law recognizes as sufficient to justify officers acting quickly rather than waiting outside while a genuine emergency unfolds behind a closed door. And it draws a clear, honest line around the limits of that authority, too. Officers cannot use a vague, generic concern as a blanket excuse to enter your home. The standard requires something real and specific, evaluated fairly, on the facts actually available at the time, which protects against the opposite fear. That this ruling somehow opens the door to officers entering homes on nothing more than a pretext. There is something worth sitting with about how this case actually resolved that goes beyond the legal rule itself. A woman on the phone with someone she loved made the hardest kind of call anyone can make, not knowing what she would find on the other end of it, and she did the only thing available to her in that moment. She called for help and gave the dispatcher everything she knew. 9 justices unanimously looked at exactly that chain of events and confirmed that the response it triggered, officers walking through a door they had not been invited through, based on nothing more than what she told them and what they could see for themselves, was exactly what the Constitution allows and exactly what it should allow, when someone's life may be on the line and there is no time to wait for anything more formal than that. If this helped you understand a ruling that could genuinely matter on one of the hardest days of your life, either as the person calling for help or the person someone is calling about, hit like so it reaches other people who might need this information someday without ever expecting to. And subscribe if you have not, because I cover rulings like this the moment they are decided, with the actual legal standard explained clearly, rather than buried in language that is hard to use in a real emergency when you actually need it most. This is not the kind of video meant to sit in the abstract. It is meant to be the kind of thing you remember months or years from now, in the exact moment you are dialing 911 with shaking hands, when knowing that specific concrete details actually matter legally could be the difference between officers hesitating outside and officers acting the moment they arrive. Tell me in the comments if this is the first time you have heard the phrase objectively reasonable basis explained in plain terms, because that tells me how much more foundational context is worth building into videos like this going forward. and whether a follow-up video walking through exactly what to say step by step on a call like this would be useful to put together next.